Hello and warm greetings. Welcome to the Analyst by Vajiram and Ravi, where we would try to comprehensively analyze 7 articles in 2 different sections. In the analysis part, we'll first have a comprehensive discussion with respect to the importance of the Panchayati Raj institutions in India, the challenges being faced by them, and the reform measures needed. Then, in the second article, we'll have a discussion with respect to the meaning and importance of alternate dispute resolution mechanisms in India and the way forward. Then, in the simplified section, we'll have a look at 5 different articles from a special perspective of UPSC Prelims 2025 along with the value addition. So stay tuned. Now coming to the very first article of the day, this is with respect to grassroots governance, the Panchayats. Now we often say that the real India, that is Bharat, it lives in its villages. Now this points towards the indispensable role played by the villages in the overall developmental path of the country. And this was also emphasized by Gandhi when he gave his concept of the oceanic circles of power, which was with respect to his vision of governance and self-rule. Now, this concept of oceanic circles of power, it basically incorporates 3 things. First is the decentralization of power. Second is the grassroots democracy. And third is the self-sufficiency principle. So what we can say is that the Panchayati Raj institutions in the country, they are at the very heart of the development. But again, what we have seen in the last many years is that there are very serious issues with respect to the functioning of these panchayats. Definitely, there have been some of the examples which we can cite as very good case studies. But again, there are issues, and we will today comprehensively look at the Panchayati Raj institutions. What is its importance? What are the issues plaguing the system? And again, what can be the way forward? Now, this is a part of GS2, Indian Constitution Amendments and Significant Provisions. Now, whenever we talk about the constitutional aspect of the Panchayati Raj systems, what you must remember is Article 40, right? Which basically gives a directive to the state to basically organize village panchayats and endow them with sufficient power and authority so as to let them function as the units of self-government, right? That is a directive which is given to the government in the form of Article 40 of the Constitution of India. Now again, we already had this particular article in the Constitution, but what we saw was that the structure of the panchayats in different states, it was not uniform, right? And this was a reason that the government of that particular day decided to come up with various committees and commissions, right? To come up with various committees so that they can basically research and give out recommendations for having a more uniform pattern of panchayats across the countries. So the first initiative was that of the Balwant Rai Mehta Committee. Now this basically emphasized that there has to be a 3-tiered structure with the Gram Panchayats, then the Panchayat Samiti, and then the Zilla Parishad. Then we had the Ashok Mehta Committee of 1978, which basically emphasized upon having a 2-tiered structure and giving taxation powers to the panchayats. Then we had the GVK Rao Committee of 1985, which basically talked about the importance of the Zilla Parishad when we talk about the development, right? And also it said that there has to be the appointment of District Development Commissioner, right? Then we have the LM Singhvi Committee, which basically talked about the constitutionalization of this tier of government and also recommended that there has to be this aspect of Nyaya Panchayats, right? So these were the very important committees. Now, it was on the basis of these recommendations, all these committee, the research work, that the Parliament basically came up with the 73rd Constitutional Amendment Act of 1992, which basically introduced this 3rd tier in the Constitution itself. It formalized, it constitutionalized this aspect. So we had a new part, we had Part 9, and we had a new schedule, Schedule 11, which have 29 subjects. Now again, what you need to understand is that this particular constitutional amendment tried to have a more uniform structure around the country, right? So it talked about the elections, it talked about the finance, right? Very important. But again, what you must know that we had a particular article, that is Article 243M, which basically restricted the application of the 73rd Constitutional Amendment to these scheduled areas, right? So therefore, we had a particular committee under the chairmanship of Mr. Bhuria, and that basically recommended, it gave its recommendations in 1995. And ultimately, the government came up with the Panchayat Extension to Scheduled Areas 1996, which basically ensured the self-rule in tribal areas, which gave absolute autonomy to the Gram Sabhas. And the state legislature and the government, the state government, can only now play an advisory role, right? So this is the whole structure. Now what you need to understand, as I said, that we have a 3-tiered structure. That is, we have in the panchayats, the district panchayat. First we have the village panchayat, then we have the intermediate, and then we have the district panchayat. Now, What all are the important constitutional provisions related to the Panchayati Raj institutions? Very important. See, the reason why I'm telling you all these is because, again, there can be a probable question in the prelims, right? And you must be aware with respect to important articles. Whenever we talk about, let's say, a particular institution, whenever we talk about a particular aspect of the constitution, you must be aware with respect to the important articles. So we have Article 243B, which basically talks about the direct elections of the members at the three levels, at the three tiers, be it the Gram Panchayat, be it the Panchayat Samiti, or be it the Zilla Parishad. Next, we have Article 243D, which basically talks about the reservation aspect. That is reservation of the marginalized community, be it the scheduled caste, be it the scheduled tribes. It also talks about the 1/3 reservation for the women, right? Do remember. Next, we have Article 243G. Now, this basically empowers the state legislature to provide authority to the panchayats so that they can function as the institutions of self-government, right? Next, we have Article 243H, which basically empowers the state legislature that they can endow or give the authority to the panchayats to levy, collect, or appropriate taxes, right? So this is important. Next, we have Article 243I, which basically talks about the formation of the State Finance Commission, which basically recommends the distribution of the net proceeds of taxes, right? Then we have 243K, which talks about the establishment of the election commission in the states so as to have the regular and free and fair elections to these bodies, right? So these are the important articles. Now talking about the significance of the Panchayati Raj institutions. The very first is that it strengthens the grassroots democracy. What we are actually trying to say is that it basically makes sure that the people on the ground, they are directly participating in the overall politics of that particular region. And then it would infuse the spirit of democracy among people. It would infuse the spirit of transparency and accountability, right? Very important for the overall governance. If you can just look at this particular infographic. Now, this data is from 2020. It says that the number of Gram Panchayats, including the traditional local bodies, it's almost 2.7 lakhs. Then the number of block panchayats, almost 6,600. Then the number of district panchayats, as of now, it's almost 700. Then the number of elected members of the PRIs, almost 31 lakhs. Number of elected women representatives. This is very important. What the data says is that almost 46% of the elected representatives in the Panchayati Raj institutions, they are women, which is far above than that of what was mandated. The reservation was 1/3, 33%. But right now what we have, the number is of the women participating in the Panchayati Raj institutions as 46%. Next, the Panchayat, number of PRIs in the country. Now this basically adds at the block level, at the district level, and at the village level, right? Almost 2.75. So this is a huge number, right? Next is decentralization of power. What we have come up with is a 3-tier structure. What we are saying is that the appropriate structure, be it the Panchayat Samiti or be it the Zilla Parishad or be it the Gram Panchayat, they have the adequate responsibilities and powers. So they have to manage that domain within themselves, right? So there is a proper structure which has been given. Then rural development, very important. According to the data by the Ministry of Rural Development, annually these panchayats are responsible for the spending of to the tune of 1.5 to 2 lakh crores with respect to the developmental projects. Huge number. And this is with respect to different sectors, be it agriculture, be it education, be it health, be it infrastructure, right? Again, what you should know is that there is the example of Hewara in Uttarakhand and the Peda Ambarpet in Telangana. Now, these are actually deemed as developed panchayats because of the kind of reforms they have taken place, right? So very important. Fosters inclusivity and empowerment of women. What we are trying to do is we are having this reservation aspect for the marginalized sections of the society, be it the scheduled caste, be it the scheduled tribe. Also, we have the reservation for the women. Now, this promotes the inclusivity. It empowers the women, right? So they feel that, yes, they are a part of the decision-making process, right? And almost what you should know is that in many states, the participation of women is more than 50%, right? Next is it is in line with the Sustainable Development Goals. See, please understand that these panchayats are the closest to the people, right? So they are in the best capacity to implement the Sustainable Development Goals. Sustainable Development Goals, they have the localized aspect also, right? So some areas may need something, the other areas may need something different. So again, what we're trying to say is that these panchayats ensure that there is proper localization of the Sustainable Development Goals and they are in a better capacity to implement them, right? Local aspirations. So basically they cater to the local aspirations, poverty alleviation, education, water. There have been many schemes. For example, be it the Pradhan Mantri Awas Yojana, be it the Manrega, right? So Manrega, for example, is a very important poverty alleviation mechanism, right? Let's say then we have Swachh Bharat Abhiyan, which focus upon the health aspect also, right? So these are very important. Address climate change. What you must know is that these panchayats, they give a very important role to the traditional practices, right? Traditional natural resource management. Again, these practices are really important once we are talking about the adaptation mechanism with respect to the brunt of the weather events which we are witnessing because of the climate change. Next aspect is mitigation. Be it soil conservation, be it the water resource management, these panchayats basically follow these principles, follow these norms, and therefore they can mitigate the ill effects of the climate change. Next is social cohesion. What we are trying to say is that since you are incorporating, since you are integrating people from various sections of the society at the ground level, this promotes the feeling of a community ownership. It fosters goodwill among the people, right? So this is very important. Next is preserving local culture and traditions. As I just said, that they emphasize upon the local culture and traditions, the local practices, more sustainable in nature, right? So therefore, this becomes very important. So these are some points which basically tell us the importance of PRIs in India. Now, what have been the various initiatives taken at the national level for the Panchayati Raj institutions? The very first is Rashtriya Gram Swaraj Abhiyan. See, what we are trying to do through this particular abhiyan is, through this particular mission is, that we are focusing upon the capacity building and the training aspect of the officials, of the elected representatives who are a part of these PRIs, right? Again, what we are also trying to focus upon is strengthening the Gram Panchayat Bhavans, be it the infrastructure, be it providing the basic necessities. So that is the aspect. Next is the 22 languages e-Gram Swaraj. First, understand what is e-Gram Swaraj. Now, e-Gram Swaraj is a platform, is an online platform, which tries to link all the panchayats across the country. Now, through that particular platform, what happens is that these panchayats are in a better position to plan their budgets, to basically implement a particular policy, to have this particular source of funding, right? Now, what the government has done is, previously it was only available in a specific language. Now, the government is saying that we would be providing the e-Gram Swaraj portal in 22 different languages. This is based on the vernacular needs. Because see, we live in a country where after every 1 or 2 kilometers, the dialect changes, right? So again, that is very important over here, that the government is also trying to link the AI models. For example, we have Bhashini tools, right? Always remember that, these things, the AI technology or the initiatives by the government. So we have different initiatives in different domains. They are now being integrated, right? So Bhashini is now being integrated to provide the e-Gram Swaraj in different languages. Next is the e-Panchayat Mission Mode project. Through this, what we are trying to do is, we are trying to integrate the information and communication technology, ICT, in the overall delivery to make the public service delivery more efficient, to have a more effective governance, right? Next aspect is localization of the sustainable development goals, as I just told you, right? So again, the Ministry of Panchayati Raj is making sure that we follow an approach where the sustainable development goals, ultimately it is on the ground where these SDGs have to be implemented. So therefore, naturally the PRIs play a very important role according to their local needs and aspirations. Next is PISA, capacity building and training. See, I just told you before this that we have the Panchayat extension to scheduled areas. Now, what we are trying to do through this is, it is a capacity building and training program where we are focusing upon the tribal leaders, right? Giving them adequate skills so that they can actually manage, they can have a proper sync with the administration, be it the district administration or be it the state government. Next is Swamitva, right? So it basically focuses upon the survey of village areas and the monitoring with the help of improvised technology in the village areas. What we are doing through Swamitva scheme is that we are trying to have a record of rights for the inhabited areas, what we call as Abadi areas, right? So that we have a proper data with us, right? And it would help in the efficient governance process. Next is geotagging of assets. In order to make sure that we have a robust public service delivery, we are also coming up, the Ministry of Panchayati Raj has also come up with a particular software, which is MSoft app. Now, this basically tries to geotags the different assets which are being created, be it through Manrega, be it through other initiatives. So whatever asset is being created, it is now being geotagged. Next is Gram Urja Swaraj Abhiyan. Through this, we are trying to integrate the renewable energy in the Panchayati Raj systems, right? So this is very important, and these schemes are really important for your exam. Now, coming to this particular article, this article is basically talking about a particular report. The report is Status of Devolution to Panchayats in Different States, an Indicative Evidence-Based Ranking. Now, this report is important because it is talking about the kind of devolution which we have witnessed from the central and state to these panchayats, right? Now, again, understand, this particular report has been published by the Ministry of Panchayati Raj and Indian Institute of Public Administration. What it says is that it basically gives an overall ranking, and then it gives the sector-specific ranking, be it with respect to the framework, functions, finances, functionaries, capacity enhancement, and accountability. Overall, what we see is that Karnataka ranks first with an overall score of 72.23. Then it is followed by Kerala and Tamil Nadu. Then we have other states, for example, Maharashtra, Uttar Pradesh, Gujarat, and other states. Now, these are the 6 key criteria. For example, framework, then you have the accountability aspect, then you have got the functions, then you've got functionaries, finances, capacity building, right? Just have a glimpse through it, may be important. Now, what are the issues or challenges being faced by these Panchayati Raj institutions in the country? See, we have a very elaborate work of the Second Administrative Reforms Commission, which has given the reasons, the issues which are being faced by these Panchayati Raj institutions. The very first is, as we have always studied, the inadequate devolution of functions, funds, and functionaries. Let's first talk about what do these 3 terms mean. So we have functions. What are the functions? These are the responsibilities and the duties which ideally these PRIs are mandated to do. Next is the funds. That is the kind of financial resources needed to implement these projects. Then we have functionaries. What do we mean by functionaries? We can have the officials or the elected representatives, right? So we do not have the adequate number of staff, right? This is what is being said through this particular argument. Now, if you just look at this particular infographic, a very, very important infographic. Let's look at chart 3. Now, this talks about the revenue per panchayat in percentage terms in the financial year 22-23. It says that the own tax revenue per panchayat was just 1%. Can you see? So, panchayats are actually having their own tax revenue as a share of the overall revenues they have. It's just 1%. The own tax revenue is just 1%, right? Own non-tax revenue is 3.8%. Just look at the kind of dependency they have on the central government, the grants, almost 80%. Then on the grants received from the state government, almost 15.5%. Next, look in the absolute terms, right? What it shows is the average revenue per panchayat in 22-23. Now, this is in absolute terms. Per panchayat, the own tax revenue is just 21,000, right? If we go on an average basis. So on an average basis, per panchayat only has 21,000 of the own tax revenue and just 73,000 of the own non-tax revenue. If you look at the kind of grants received from the central government, it amounts to almost 17 lakhs. And the grants received from the state government, almost 3.27 lakhs, right? So this is what the picture is. Now, if you just look at this particular infographic, over here, what it is showing is the revenue of panchayats as a share of state's own revenue in 22-23. Over here, the UP performs quite good because the percentage is 2.5. So what we are trying to say is still there is a huge dependency upon the central government or the state government. They are not having the taxation powers. The state legislature is not basically devolving those powers to these PRIs. Also, we have the report by the Ministry of Panchayati Raj in 2021. It says that we have the 11th schedule, which actually has 29 items, which talks about the power, responsibilities, and authorities of panchayats. But what it says is that only 5 have been devolved out of 29 to most of the states. The rest have not been devolved. Next aspect is that of the vacancy. So we have a data from the Ministry of Rural Development, which says that there is almost a vacancy of 30% when we talk about the panchayat secretaries. So you must be familiar about the panchayat secretary. So we have Tripathi ji in the panchayat of Amazon who plays or who is basically a panchayat secretary. Now, next aspect is capacity constraints and lack of training. See, what we are trying to say is even if when we have the officials and elected representatives, they do not have the adequate capacity. They do not have the adequate skills, be it the leadership skills or the managerial skills or the financial management. So that is a part which is lacking. So we have the report by the Indian Institute of Public Administration of 2017, which says that almost 60% of the elected representatives, they lack these skills. Next is multiplicity of agencies and a lack of coordination. You must have heard about the special purpose vehicle, or you must have heard about parastatal bodies. Now, these bodies are actually, their mandate is to fulfill a particular function. Now, we have multiplicity of these agencies fulfilling different functions. Now, this leads to chaos and confusion. Ideally, the task has to be done by the panchayats at the ground level. But we have a lot of missions, we have a lot of programs being actually run by different entities. So that creates confusion. Next aspect is that of interference from bureaucracy and state governments. What we are trying to say is, time and again, there has been a complaint that the state government unduly interferes in the overall functioning of these PRIs, right? It affects their autonomy, it affects their ability to deliver, right? Also, we have a data that 14th Finance Commission from 2015 till 20, it basically devolved resources to the tune of 2.87 lakh crores. It recommended, and it says that these resources were actually devolved, but these resources were not properly utilized because of the kind of interferences we had from the state government, or because of the delays in granting or making sure that these funds are available to these PRIs. Next is Panchayat Pati syndrome. We have always studied that. In those seats which are reserved for the women, what happens is that you have these women who are actually elected. Now, the real decision-making power is with their relatives, right? Which obviously goes against the very principle of the democracy, right? So this is a very serious issue. Now, PRS, legislative research, has also talked about it. Next is insufficient data and monitoring mechanism. The issue is that we do not have adequate, robust data with us. Data is really very important once we talk about the policy implementation aspect, or once we talk about making sure that what is the impact of a particular initiative taken by a Panchayati Raj institution, right? So that is a very cause of concern. Lack of accountability and transparency mechanism. We have been hearing cases that there is still quite a nexus at the ground level, and there is a corruption involved. Also, the CAG report of 2018 talked about the irregularities in the funding mechanism of MGN REGA, Manrega, right? Mahatma Gandhi National Rural Employment Guarantee Act. It also talked about the misappropriation of funds. Next, we have the Ministry of Rural Development report. It says, though social audit is actually mandatory when we talk about Manrega, only 30% of these PRIs are actually implementing it. Next is inadequate infrastructure and resources. These panchayats don't have the adequate building. The building doesn't have adequate public amenities, be the toilets or the drinking water. So these are the general issues which are actually plaguing the whole system. What are the reform measures which are needed? So we have certain reform measures which are actually suggested by the Second Administrative Reforms Commission itself. Now again, this information you can directly use while you are writing a particular answer, and this would enhance the credibility of your answer because these are the recommendations by the second ARC. First is strengthening the Gram Sabha. What we are trying to say is, it's not just about Gram Sabha having a supervisory role. No, you need to make Gram Sabha a body which can participate in the overall socio-economic planning process, also the implementation process. Next is devolution of functions, funds and functionaries. It has to be based on the principle of subsidiarity. Now, what do we mean by principle of subsidiarity? It says that the decision-making power should be at the lowest level. That is, the people at the lowest level should take the decisions. The upper levels of the government should only interfere if there is a need. So principle of subsidiarity has to be followed. Next is capacity building and training. We already have programs in place, but again, we need to make it more robust. Specialized institutions. Take, for example, we have Mission Karmyogi, right? Now again, if the state government can also come up, different state government can also come up with a specific capacity building program for these officials who are manning, or these staff who are actually manning these Panchayati Raj, or even the elected representatives, that can really prove helpful. Next is strengthening the state finance commissions. Though we have a constitutionally mandate, right, that there has to be the timely constitution of the state finance commission. So there are two problems. First is many states have not institutionalized the state finance commission, and even if they have done, they are not abiding by the recommendations of the state finance commission. So that has to be done. E-governance and citizen participation, again, this has to increase. If you want the transparency aspect, the accountability aspect, or the citizen participation to increase, e-governance is a must. What can be the other way forward? The first is local taxes and fees. These Panchayati Raj institutions must be allowed to basically levy and collect their own resources. State legislature must give them the adequate powers, taxation powers, so that they can have their own resources. They are not then dependent upon central government or the state government in the form of grants. Next is the self-help group panchayat linkage. Very, very important. You must have heard about self-help group bank linkage, which was an initiative originally taken under the NABARD, right? There is a need to implement this self-help group panchayat linkage. What we are trying to say is that if you will have this, then definitely, see, whenever you have these examples of self-help group, they have really proved to be very empowering for women. They have given them the economic options, economic livelihood options. Take the case of Lijjat Papad or take the case of Kudumbushri in Kerala, right? So definitely they have a huge economic potential. What we are trying to say is that if panchayats can come and then integrate with these self-help groups, definitely it can usher in a lot of economic potential, right? So that is really needed. They can have, these women self-help groups can have adequate credit, right? Panchayat can have a backing with respect to the cushion, with respect to the credit given to these self-help groups. Next is robust data collection. What we are trying to say is that if you want to have those policies in place, which basically want a desired outcome, then you must focus upon having a robust data mechanism, data collection mechanism with us, right? Because that data would help the policy planners to come up with more specific policies in place, right? Good policies in place. So what we are trying to say is, see, PRIs are indispensable for the governance. And as initially talked about, we said about the oceanic circles of power, we need to endow these Panchayati Raj institutions with sufficient power and authority, right? This has not been done. And again, the state legislatures, they are still withholding the devolution of powers to these PRIs. So again, the state legislature must come on board and these PRIs should be given adequate power, because again, if you look at the developmental aspect, nothing can be done without the cooperation of these PRIs. So they are really very important. And again, to quote Mani Shankar Iyer, what he said was that no panchayat is better than a bad panchayat, right? So what we are trying to say is we need to have a structure in place that basically gives adequate power and authority to these panchayats so that they can deliver upon these outcomes, right? So this is what you need to know with respect to the first article. Let's have a mains question. The question says, assess the role of the Panchayati Raj institutions in deepening the grassroots democracy in India, discuss the key challenges faced by the PRIs in ensuring effective local governance, and suggest measures to strengthen their functioning. 15 marks, 250 words. Do write a particular answer to this question. And yes, do not forget to like if you are liking the initiative. This is a kind of platform where we are focusing, we are making sure that you get the enriched content. Let's go to the next article. So coming to the next article, this is with respect to alternate dispute resolution. So recently, the Chief Justice of India, Mr. Sanjeev Khanna, has said that there is a dire need of having mechanisms like mediation for dispute resolution. And not all the disputes are supposed to go to the courts, right? So this points towards the importance of the alternate dispute resolution mechanism we have in the country. So we'll see what is its meaning, what are some of the issues, and what can be the way forward. Now, this is a part of GS2, judiciary, government policies and interventions. Now, let us first talk about what do we mean by alternate dispute resolution. See, if you just look at the kind of definition which is provided by the Investopedia, it says it is a process used to settle disputes outside that of the courtroom. What we are trying to say is that this is a mechanism, this is a method of resolving the disputes which does not involve a proper trial, which does not involve a proper courtroom procedure, what we have in the litigation process, right? Again, since it does not involve the courtroom proceedings, this is a process what we call as a non-adversarial process, because the parties are not basically confronting each other, right? They are basically sitting together and mutually discussing and then coming to a conclusion. Now, it basically involves the spirit of working together in a cooperative manner. Next aspect is creative and collaborative efforts are needed by every stakeholder, right? It's not like a formal court proceeding where the judge actually, says the order, passes a decree, and that becomes the final word, right? Now, this is a win-win situation. See, normally what happens in a courtroom proceeding is that it's a zero-sum game. Someone would be benefited and someone would be at loss. But in this particular ADRs, what we see is that it is a win-win situation for all these stakeholders, because they are actually discussing, or let's talk about the arbitration or any other mechanism. Over there, they are having a mutually agreed solution, right? So this is a win-win situation. Primarily, it is of 4 types. For example, we have the arbitration. So what happens in arbitration is that you have an arbitral award, which is actually binding in most of the times to the parties, right? Next is we have conciliation. So what conciliation means is that you have a particular person as a conciliator who basically acts as a conciliator between two parties and plays a very active role in that part. But the decision is, however, not binding. Let's talk about mediation. In the mediation, what happens is that you have a person as a mediator between two parties, a third party as a mediator between two parties, but he or she plays a passive role, right? Not an active role. Again, the decision is not binding. Then we have negotiation. What happens in a negotiation is that there is no involvement of the third party. Directly the parties sit and then they reach to a mutually agreed negotiated settlement. These are the 4 kinds of ADR techniques we have. Next is, what is the constitutional and legal basis of ADR in India? So if you look at the constitutional basis, we have Article 14, which talks about the equality before law and equal protection of laws. Then we have Article 32, which talks about right to seek constitutional remedies, right to seek justice. Then we have Article 39A, which talks about the equal justice and the need for having free legal aid, right? Next aspect is legal basis. Are there any legal basis for ADRs in the country? The answer is yes. Let's talk about the Legal Service Authorities Act of 1987, or talk about the Arbitration and Conciliation Act of 1996, or talk about the Gram Nyayalayas Act of 2008, or talk about the Mediation Act, the recent one of 2023, right? Next aspect is that of plea bargaining. What do we mean by plea bargaining? So what happens is, let's say you have a particular person who is accused of a particular crime. In this situation, the prosecution can ask that particular person to accept, to plead guilty, right? And in exchange, the prosecution would basically ask for lesser punishment for that particular person. So this is mentioned in the Criminal Procedure Code. Now, what all are the institutions which are basically handling this arbitration or let's say alternate dispute resolution mechanism in the country? So for example, we have Gram Sabhas, right? So they also work upon that. We have Panchayats, right? Form of ADRs. Then we have consumer courts, we have Lok Adalats, we have family courts, we have counseling centers. So these are the kind of the institutions which are actually implementing the alternate dispute resolution. Now talking about the benefits and advantages of the alternate dispute resolution mechanism. See, we have the report by the Law Commission, the 222nd Law Commission report, which very clearly talks about the benefits or the advantages of having ADR. So if there's a question with respect to ADR, you can definitely cite these points. The very first is judicial pendency. We have this very serious issue of judicial pendency in the country. According to the data provided by the National Judicial Data Grid, it says that there is almost a judicial pendency of cases in the Supreme Court, which amounts to almost 80,000 cases. When we talk about cumulatively for the high courts, it amounts to almost 6 million, that is 60 lakh. And when we talk about the subordinate judiciary, it amounts to almost 4.5 crore cases, too much. So what we are saying is that this ADR is providing an alternate mechanism for the dispute resolution. The parties do not need to follow the formal judicial process, right? Traditional judicial process. Next is, it is less expensive. When you compare the costs which are involved in a traditional litigation process, cumulatively, it is quite more as compared to the ADR mechanisms available. Next aspect is less time consuming. So these mechanisms, alternate dispute resolution mechanisms, they have a set frame of time under which they try to deliver the verdict, right? Or try to deliver the kind of settlement between the parties. So this involves no lengthy appeals. Next is free from technicalities. See, the traditional judicial process, it has a lot of procedures, a lot of things have to be followed, but this is not true when we talk about the ADR. So it is much more flexible and it gives that room to the parties. They can share, they can basically give their own points and then they can reach to a mutually agreed solution. Next is confidentiality. When we are talking about confidentiality, what we are trying to say is that this process makes sure that the data is not diverted to the public, is not divulged to the public, right? So it make sure that there is proper confidentiality with respect to the stakeholders of the process. Next aspect is that of continuing relationship. See, when we talk about the traditional process or the normal judicial process, it creates an adversarial relation between the parties because one party loses, the other party wins. In this particular case, what happens is it's a win-win situation. So this fosters the reconciliation among the different parties. Next is improved enforcement. It has been observed that with the help of these ADR mechanism, the speed of contract enforcement increases. And this is a very, very important part if we want to talk about the enhancing the ease of doing business, which has also been talked about by the World Bank. Next aspect is that of saving the forex reserves. See, you must know that there are some of the very important international arbitration hubs, for example, be it in Singapore or be it in Hong Kong. Now, they are the preferred destination for many of the businesses. But now, since India is also coming up with these institutions, arbitration institutions, the parties can domestically solve a particular issue. So they would not waste the very precious forex reserves we have. What are the limitations of alternate dispute resolution mechanism? The very first is lack of awareness. See, let alone the people, do not talk about the common people, even the people from the legal professions, they are not very clearly aware about the kind of processes we have in the ADRs. So that is one of the very important issue. Next aspect is that of good faith requirement. See, if parties want to have a particular ADR mechanism, they should have trust among themselves. If the trust is missing, definitely they would be more inclined to go for a formal judicial process. Skepticism, they are not really sure whether the particular process would be advantageous for them or not, and this results to a sort of inclination for having a formal court proceedings. Next aspect is it is voluntary process. What it means is that the process gives primacy to the mutual consent. If the mutual consent is missing, definitely the solution won't be possible. Then we can talk about the forcible transfers. There have been cases where the traditional judiciary has forcibly transferred the case to these ADRs. Now, even if the parties are not, one of the parties is not agreeing to it, the judiciary has passed to the ADR platform, and therefore it is something which goes against the interest of that particular stakeholder. Neutral arbiter bias. Let's say we have a particular arbitrator who has come up with a particular decision. Now, the losing party may say that this particular arbitrator was biased, and therefore it definitely affects the credibility of the system. Limited scope. That is, whenever we are talking about the ADRs, it's just applicable to the civil and the monetary cases, disputes, right? It is not applicable to the serious criminal offenses. That is one aspect. Limited appeal. Whenever we talk about the arbitration, we definitely say it's binding, but there are certain conditions on which the decision can be challenged, and therefore it leaves scope for the, for having arbitrary decisions. So that is one of the aspects. That is the reason that people are more inclined to go for the formal courts, right? What should be the way forward? First is speedy and successful alternate dispute resolutions. We need to come up with more initiatives. For example, let's talk about the e-lok adalats, or let's talk about the scope of pre-litigation mediation. We need to focus upon the pre-litigation mediation so as to reduce the judicial pendency and convince the parties to a case that, again, the kind of process which you are going to seek, or the kind of judicial process you are actually willing to go for, that would take a lot of time, and this would not serve the purpose. Promote ADR as a career. We need to have a strong cadre. We need to have a well-defined, a well-professional workforce with respect to the ADR mechanisms. So there's a need to have well-trained arbitrators and mediators. Reducing judicial pendency. What you must know is that the government is the major litigant. More than 50% of the cases here are those cases where you have the government as the major litigant. So that is one of the issues, and therefore we have to reduce the judicial pendency. Coordinated efforts. It's not just that only these platforms or only these arbitration council can help. We need the support, as the Chief Justice of India has said. Now, it is good on the part of the Supreme Court that it is trying to enhance the mechanism of the ADRs. So there is a need for coordinated mechanism, be it the judiciary or the government or the legal professionals. Next is attitudinal change, very important. One aspect is there has to be greater awareness. The second aspect is people should be more inclined for these ADR, because traditionally or psychologically what they feel is that they would get a relief in a traditional court process. They are not really inclined to go for the ADR mechanism. So there has to be this attitudinal change. Other measures should be to boost the infrastructure with respect to these centers, to focus upon the capacity building and training of these professionals who are a part of these ADR mechanisms, right? So what we are trying to say is, definitely, when we talk about reducing the judicial pendency, when we talk about faster disposal of cases, when we talk about enhancing the ease of doing business, ADR is something which is really very important. So we need to promote it. But again, there are issues. We need to focus upon these issues and come up with these solutions. So that is what you need to know with respect to this article. Let's have a mains practice question. The question says, alternate dispute resolution mechanisms have emerged as an effective means of reducing the burden on the judiciary while ensuring timely and cost-effective justice delivery. Critically examine the role of ADR in India, highlighting its advantages, challenges, and the way forward for its wider adoption. 15 marks, 250 words. Do write a particular answer on this question. So coming to the simplified section, we have the first topic, which is the Central Vigilance Commission, a very important body, and yes, very important for the upcoming prelims exam. Now, the Central Vigilance Commission has directed the Central Public Works Department, CPWD, to conduct a probe and to find out whether you had the merger of several government properties so as to create a big bungalow for the former Chief Minister of Delhi, Mr. Arvind Kejriwal. Now, we won't go into the political aspect of this particular news, but what becomes really important is this, the functions, the role and the mandate of the CVC, Central Vigilance Commission. Now, this is a apex institution, vigilance institution, which exercises superintendence over the vigilance administration of different organizations where the executive power of the government of India extends. You must have seen that we have different departments, and in every department we have the vigilance officers who are ultimately responsible to the chief to the Central Vigilance Commission. Now, this is an apex integrity institution having complete independence and autonomy in its functions. The CVC, initially, it was set up through a resolution in 1964 on the recommendations of the Sangamam Committee, right, for the prevention of corruption. Remember this, important. But later, it was made a statutory body, right, through the Central Vigilance Commission Act of 2003. So right now, it has a statutory status, to remember. CVC is not directly controlled by any ministry or department. It is responsible to the parliament. Now, what are the significant provisions? The very first is composition. CVC is actually a multi-member body. It consists of a Central Vigilance Commissioner, who is the chairperson, and not more than 2 Vigilance Commissioners, who are also known as the members. Organization. So CVC has its own secretariat, the Chief Technical Examiners Wing, a wing of commissioners for the departmental enquiries. Appointment. This is important. Who appoints the CVC? The Chief Vigilance Commissioner and the Vigilance Commissioners. So we have a particular committee. Ultimately, they are appointed by the President on the recommendations of a committee, which is actually headed by the Prime Minister, who acts as the chairman of that particular committee. The Minister of Home Affairs, the Union Home Minister, is a part of that. And then we have the Leader of Opposition of the Lok Sabha. Term is of 4 years from the date of which they enter the office, or till they attain the age of 65, whichever is earlier. Salary and allowances. The salary of the Chief Vigilance Commissioner is similar to that of the chairman of the UPSC, and those of the Vigilance Commissioners is equal to that of the members of the UPSC. Now, removal. Again, the kind of removal process is almost same for the other bodies also. So the President can remove the chairperson or any other member from the office under the following circumstances: if that particular person is adjudged as an insolvent, goes bankrupt, or if that particular person is responsible for involving into an offense which involves the moral turpitude, or is convicted for such an offense, or during the term of his office is involved in any paid employment outside the duties of his office, is declared unfit by the reason of infirmity of mind or body, then the President can remove. The President can also remove on some other ground, that is misbehavior or incapacity, right? But in that case, what has to be done is the President has to refer the matter to the Supreme Court for an inquiry. Now, the Supreme Court basically conducts an inquiry, and if it upholds the removal and advises so, the President can remove him. Again, it is the advice tendered by the Supreme Court is not binding. It has the powers of a civil court, therefore it makes the CVC a quasi-judicial body, right? It has all the powers of a civil court while conducting the inquiry. Its proceedings have a judicial character. It can ask for any information, call for evidences, summon a particular person, right? Call for public records. That is what the body is, and that is what we call as the quasi-judicial powers, right? Advisory nature. See, again, after the inquiry, it advises the central government or its authorities for further course of action. Now, if the central government accepts, it's fine. If the central government doesn't accept, then it has to communicate the reasons to the CVC. The government has to communicate the reasons to the CVC. Investigation work. Whenever we talk about the investigation aspect, the CVC, it is actually dependent upon some other bodies. For example, we have the CBI or the Chief Vigilance Officers, what we call as CVOs. It presents an annual budget to the President, which is then placed before the Parliament. Now, what are the powers and functions of the Central Vigilance Commission? See, again, whenever we talk about the aspect of superintendence, please note, this is really very important. It exercises superintendence over the functioning of the Delhi Special Police Establishment, right, which we call as the CBI, Central Bureau of Investigation. Now, a question in front of you guys. Tell me whether CBI is a constitutional body or a statutory body. Or if neither of them, what kind of body CBI is, right? And see, again, what we are saying is CBI basically investigates different types of cases, be it serious criminal charges, or be it those offenses related to the extraterritorial jurisdictions, or be it with respect to, let's say, the High Court or the Supreme Court orders, then CBI does so. If, let's say, the state government asks the request or requests the CBI to investigate a particular case, then CBI does so. So it has different kinds of cases, the investigation which it performs. Whenever the CBI is performing or investigating a case with respect to the corruption, which relates to the Prevention of Corruption Act, the overall jurisdiction under which it would work would be the Central Vigilance Commission. Always remember. It exercises the superintendence over the vigilance administration of the various central government ministries, departments, and organizations. Monitoring under the Prevention of Corruption Act. Whenever we talk about Prevention of Corruption Act, remember that CVC is the apex body. It reviews the progress of the investigation conducted by the CBI, what we call as a Delhi Special Police Establishment, into the offences alleged to have been committed under the Prevention of Corruption Act. It also reviews the progress of applications pending with the competent authority for the sanction of prosecution under the PCA Act. Now, inquiry on reference by the central government. So it can inquire or it can cause an inquiry or investigation to be made on a reference by the central government. Recommending disciplinary action, it can also recommend that this action has to be taken against this particular officer. It recommends a particular action for against higher officials of Group A, B, or India Services. Now, it can also call for information from any of the central government or any of its, a department or any of its body which is established by an act of the parliament. Now, what are the other functions? So, other functions under the Lokpal and the Lok Ayuk Act of 2013. Whenever we talk about the appointment of the Director of Prosecution, so there is a Director of Prosecution in the CBI, right? Whenever we talk about the appointment of this particular person, it has to be on the recommendation of the CBC. Always remember. Now, the next point becomes very important. See, there is a particular selection committee which comprises of the Central Vigilance Commissioner and the two Vigilance Commissioners, including the Secretaries of the Home Affairs and the Department of Personnel and Training. Now, they basically recommend the name of the officers to the post of the level of Superintendent of Police and above in the CBI. So we have a committee which comprises of the Central Vigilance Commissioner, the two Vigilance Commissioners, the Secretary of Home Affairs and the Secretary of Personnel and Training. They recommend the name of the officers who are to be appointed at the level of the SP and above in the CBI, except the Director of the CBI. Now, in this particular committee, if you add the Secretary of the Department of Revenue, so it would make the Chief Vigilance Commissioner, the two Vigilance Commissioners, the Secretary of Home Affairs, Personnel and Training, and the Department of Revenue. So it's a 6-membered body. Now, this body is actually responsible for recommending the names to the post of Director of Enforcement. Do remember, very, very important. CBC has been empowered to conduct the preliminary inquiry into the complaints referred by the Lokpal in the respect of officers or of Group A, B, C. Powers and functions with respect to the whistleblower. This is very important. See, we have certain people working in departments. When they come across the news with respect to the corruption, they can definitely go and to a particular body, specific body, and then disclose that particular information. Now, the body which is actually mandated that to whom we have to go is the CBC, and there is a particular process, right? So CBC has come up with proper guidelines which basically try to make sure that the whistleblowers who are actually disclosing the information, their life is not at stake and they are actually saved. They have a proper safety mechanism in place, right? So this is what you need to understand. CBC, a very important body. Probably a question can be asked in the prelims. Let's go to the other article. Now, coming to the next article, this is with respect to a very important provision mentioned in the Constitution of India, which is Article 311. Article 311 talks about the dismissal, removal, or reduction in the rank of the persons employed in civil capacity under the union or a state. Now, what you need to understand is what the news says is that we have the Lieutenant Governor of the Union Territory of Jammu Kashmir, who has basically terminated the services of 3 persons. Now, already 63 people have been terminated so far using Article 311, right? So the article says is the Lieutenant Governor of Jammu and Kashmir, Shri Manoj Sinha, on Saturday terminated the services of 3 more government employees in the Union Territory over the alleged militants, over the links with the militants, right? So they had alleged terror links, and on that basis, they have been terminated from the service. Now, again, what is the very objective of Article 311? What you must know is that Article 311, it tries to provide the safeguards to the civil servants and the government against arbitrary dismissal, removal, or reduction in the rank, and it ensures that employees are given a fair opportunity to defend themselves. That is the very objective of this particular article. Now, Article 311, it lays down the procedure and the safeguards to be followed before a civil servant can be dismissed, removed, or reduced. Please remember, we are talking about 3 words: dismissal or removal or reduction in the rank. It is not talking about the suspension or transfer, right? Do remember, there's a difference. So these 3 things are only covered, either the dismissal or the removal or the reduction in the rank. This does not apply to the military personnel. Now, Article 311 specifically deals with the dismissal, removal, or reduction. It does not cover suspension or transfer cases. Again, if you have probationary officers, so they are not made permanent, they do not enjoy the kind of safeguards which are available to the permanent employees under Article 311, right? So probationary officers do not enjoy the same level of protection under Article 311 as confirmed employees. Therefore, those on probation can be dismissed without inquiry. Now, this next provision which I am going to tell you is very, very important. Article 311 subclause 2 subclause B says that which it basically allows the president or the governor to waive the inquiry process inquiry process would not be needed if holding such an inquiry is not feasible due to the concerns over public security or the efficient functioning of the government services. So this you must know, very important. Article 311 can be probably a question can be asked in the prelims. Let's go to the other article. Coming to the next article, this is with respect to the Indian Council of Medical Research. So the ICMR is seeking partners for the commercial production of a vaccine against typhoid. So what the article says is that the ICMR is looking for joint development and commercial production of a typhoid and paratyphoid vaccine. It is then talking about the disease as such. Typhoid is a bacterial infection that affects the intestines and even sometimes the bloodstream caused by the bacteria Salmonella typhi, right? The infection is spread by the consumption of contaminated food or water. The sources of the infection are mentioned here. Contact with the feces or urine of an infected person, or it can be also because of the sexual contact. It can be life-threatening if untreated. Treatment includes the use of antibiotics. For example, we have ciprofloxacin or we have ampicillin. Now, what is a kind of formal process? Not really important, but again, let's go through it. The objective of the ICMR is to validate the broad specificity of typhoid and paratyphoid vaccine. What do you mean by specificity of a particular medicine? It refers to, if saying how to validate the specificity, whether the particular vaccine is working against that particular target or not, or is it affecting other organs also. So that is what we validate in the specificity. Developed at the institute, this would be followed by proper regulatory compliances, commercialization and marketing. Recent studies show that the typhoid is considered as a significant public health issue in India, with estimates suggesting that the country bears a large burden of typhoid cases globally, with millions of cases reported annually, particularly concentrated in urban areas. Look at this. So again, this is a very serious public health issue, right? Making it a major menace in the region. A study found a national incidence of 360 cases per 1 lakh people, translating to approximately 45 lakh annually, right? 4.5 million. Let's also study about the ICMR, can be really important for the prelims. Now, it was initially set up in 1911. The government of India first set up the Indian Research Fund Association with the specific objective of sponsoring and coordinating the medical research in the country. So the overall, it's a pioneer organization when we talk about the medical research, very important organization. After independence, it was redesignated as the Indian Council of Medical Research. Please note that it works as a society under the Societies Registration Act of 1860. What is the mandate? It's the apex body in India for the formulation, coordination and promotion of biomedical research, conducts, coordinates and implements medical research, translating the medical innovations into products. That is what the article is talking about. So it made a particular product. Now it is trying to commercialize and go for the joint production. Vision is translating research into action and improving the health of the population. Organizational structure, important, can be asked. The governing body of the ICMR is presided over by the Union Health Minister. It is assisted in its scientific and technical matters by the Scientific Advisory Board, comprising, you have different domain experts in different biomedical disciplines. Research is carried out currently in the council's numerous permanent research institutes. So it has more than 30 research institutes across the country. For example, some of them dealing with the nutrition, some of dealing with a specific disease, for example, cancer, right? Which are mission-oriented national institutes located in different parts of the India. A question can come with respect to ICMR, so you can have a look over there. So coming to the next article, this is with respect to the third edition of the Kashi Tamil Sangamam. Right now, this is taking place in Varanasi. Quite important when we talk about the art and culture aspect. Now, the very gist of the article is that we have the civilizational connect between the North and South India. And this is one of the component. This is one of the schemes through which we are trying to have more closer relations between North and the South. The cultural aspects, there would be focus upon art and culture. So this becomes really important. It is a part of Ek Bharat, Shresth Bharat, right? So let's go through the article. Inaugurating the third edition of the Kashi Tamil Sangamam in Varanasi, the Uttar Pradesh Chief Minister said that it's a unique event signified India's cultural foundations, noting that the Kashi and Tamil Nadu had been sharing an emotional and creative bond since time immemorial. Now this is very true because for thousands of years, these two places have been the cultural centers for religious activity, very important. The event is inspired and guided by the Prime Minister's Narendra Modi's vision of Ek Bharat, Shresth Bharat, which focus upon the cultural integration among different parts of the countries. This year, the Sangamam is also bearing the integrated with the grand Mahakumbh celebrations. So again, what you need to understand is what the Chief Minister has said, that this is coinciding with the Mahakumbh. So it's a very special event. and elevates the centuries-old tradition to new heights. Mr. Adityanath reiterated the historical significance of Kashi as a center of India's cultural heritage and spirituality. He hailed the legacy of Tamil literature, one of the world's oldest literary traditions. So we many times talk about the Sangamam literature. So this becomes very important. This edition is held with a vision that unites India's saint tradition, scientists, social reformers, and students, drawing inspiration from Maharshi Agastya. Very important. Regarded as the father of Tamil grammar, right? He was the one who basically started off, having closer relations. The North and the South should have closer relations. A very important saint, right? Also, he wrote the Agastya Samhita. Do remember. It is believed that the Maharishi Agastya is the sage who bridges the North and the South India, right? So if you just look at this particular event, so we have this event which is set to take place from 15th to 24th of February 2025 in Varanasi, Uttar Pradesh. Initiative aims to strengthen the cultural ties between Tamil Nadu and Kashi, celebrating their shared heritage. Edition coincides with the Mahakumbh and is the first Sangamam after the Pran Pratishtha of Sri Ramlala in Ayodhya. It aims to celebrate the legacy of Maharshi Agastya. Around 1,000 delegates would be coming from Tamil Nadu, including students, farmers, professionals, and women, right? So it would see, coming of people, and then they would, have discussions. So again, that is a mix of cultural backgrounds. People from different backgrounds are coming, and then they're deliberating. So this particular Kashi Tamil Sangamam 3 is organized by the Ministry of Education. This is important. In collaboration with various ministries and government of Uttar Pradesh, aims to encourage the cultural exchange. The Kashi Tamil Sangamam has been celebrated twice before in 22 and 23. So it's not the first time the event is being held. It's being held the third time. With approximately 4,000 delegates in participating, IIT Madras and Banaras Hindu University are implementing the agencies of KTS. Kashi Tamil Sangamam 3.0, facilitating the participation and organization of the event. This is what you need to know. If there's a probable question with respect to the KTS 3.0, you can answer with the help of this particular data. Let's go to the last article. So coming to the last article of the day, this is with respect to a gold smuggling attempt being foiled by the Border Security Force. So we have the troops of the South Bengal frontier of the Border Security Force foiled a gold smuggling attempt along the India-Bangladesh border in the North 24 Parganas district of West Bengal. So you can just see that there is again the issue of drug trafficking, or the trafficking of these precious metals, or even the trafficking of arms. So it's a very serious security issue. Again, the value of this gold, it amounts to almost 3 crore rupees, right? Too much. Now, let's talk about BSF. A question can come in the prelims. So this is one of the 7 Central Armed Police Forces of India and was raised in December 1965. It was raised in the wake of 1965 war with Pakistan and to ensure the security of the borders. It is the only CAPF, Central Armed Police Force, which has its own water wing, air wing, and other ancillary units. Do remember, headquartered in New Delhi, works under the overall administrative control of Ministry of Home Affairs. Such, many times direct questions are being asked, under which ministry this particular organization works. So you can answer. Its operational responsibility is spread over 6,386 kilometers of international border with Pakistan and Bangladesh. So which borders is it manning? The Pakistan and that of the Bangladesh. Operation during the peacetime, it prevents the trans-border crimes, as is seen in this particular article. Unauthorized entry into or exit from the territory of India, prevents smuggling or any other illegal activity. Wartime role, protection of vital installations, particularly the airfields. Limited aggressive action against the paramilitary or irregular forces of the enemy within the overall plan of the armed forces. Assistance in the control of refugees. Now, overseas deployment, so some of the troops are also deployed overseas, contributes to the personnel every year for the United Nations mission. So we have peacekeeping missions of the United Nations. So you have troops who are contributing to the UN peacekeeping forces from the BSF. It is handling the security issues of the famous Kartarpur corridor. Very important. Other roles, it is also deployed on the line of control, LOC, in JK, under the operational control of the army. So the operational control in the JK is with the army. Do remember. At the time of natural disasters, calamities, BSF provides assistance in areas of deployment such as Kashmir floods, Kerala floods, Kedarnath tragedy. So definitely whenever you have such natural catastrophes, we have seen the participation of different armed forces, be it the BSF, be it the other organizations, for making sure there is adequate prevention and there is adequate preparedness, and then there is adequate rehabilitation of the people who are suffered. Power to arrest, search and seize So BSF is empowered to arrest, search and seize under the number of laws. So we have, for example, CRPC, we have the Passports Act, we have the Passports Entry to India, we have the Narcotics, Drugs and Psychotropic Substances Act. So under these laws, it has the power to basically arrest and seize someone, to basically seize a particular product or to arrest someone. So this is what you need to know with respect to this particular article. I hope you really enjoyed this session. If you like it, do let us know through your likes and comment. All the best. Thank you.